This is The Law Matters. Of course it does. Welcome. I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, and practical assistance to help you with law matters because the law matters. A better understanding of the law puts you in a better position to decide how to protect yourself, your business, and your family. As we present various topics, as we tell you, you may find that you can handle some issues yourself. If you decide to enlist professional counsel, you'll be better prepared, and so will the professional you select. Our goal, of course, as always, is to help you to achieve the best possible results while saving time and money. And we want to, again, welcome David Bazar, attorney David Bazar from the Bazar and Associates law firm in East Providence, who continues to address the various legal topics that we tackle, and we always appreciate his insights and anecdotes as well. So today we're going to discuss personal injury cases, a perennial favorite. How do they actually work? Are personal injury cases ever a do-it-yourself project? Do you always need an attorney? What is that process if you were to do it on your own? So as it is, we know that personal injury settlements usually are major headlines. You don't always hear about all of the settlements, but admittedly, sometimes they are significant. Apparently, more than 94% of criminal cases are resolved through plea bargain rather than going to trial. Would you believe the same statistics are true of civil cases, apparently? So what we're going to do today is address the personal injury cases such as they are, and I think we should probably begin with what's the reason for a personal injury lawsuit in the first place?
Somebody is injured as the result of somebody else's negligence. It can take many different forms. People commonly associate personal injury with auto accidents, for example, or slip and falls. In some instances, it could be the result of professional negligence, such as medical malpractice. So every different type of negligence case which results in an injury to the person is considered a personal injury case.
I know at times we've talked about personal injury, the product liabilities. Maybe next session we'll talk about workers' comp. But sticking with what certainly seems to be offering a wealth of cases, car accidents to slips and falls. Let's talk about the kinds of injuries that often result that are things that you have to consider when you're dealing with clients or prospective clients, right. I guess.
So the injury is oftentimes one of the key components to whether or not an attorney wants to get involved in a case, because you could have a negligence situation where there's clear negligence, but if there's no real injury, it's not the type of case a lawyer might want to take. For example, if you're stopped at a stop sign and someone hits the back of your car, but you're not hurt and there's little or no damage to your car, it's not a case that a lawyer is going to want to pursue. So the types of things that go into determining whether or not there's a case that a lawyer will pursue would be, first of all, was there negligence? And if there was negligence, was the causal result of that negligence an injury of some substance to the person? And is there a deep pocket, so to speak, to recover from, which is often is their insurance?
And would someone likely, or would you likely take a case if it were more than one party involved with a case? I guess the simple example that comes to mind is there's one car accident that then causes another that causes someone to, when there are several people involved. If it was an insignificant case, not worth your time or whatever, the court, so however you work that out, once it gets to be more complicated, does that seem to trigger a reason for someone to pick up a phone and call a lawyer?
Well, those cases can be more complex. So certainly if there's more than one tortfeasor, so to speak, there's got to be an understanding of how the accident happened and who's responsible. And the chain reaction that you gave is often an example of, well, the first car stopped, the second car may or may not have hit the first car, and then the third car did hit the second car, but did that cause the injury to the person in the first car? And those are certain things that need to be sorted out. As a opposed to another type of joint tortfeasor situation where there are two people who are clearly responsible for the injury to one, and how you sort those out in the law is also a very interesting undertaking for the lawyer. But I think it goes back to the first issue, is the case one of significance that a lawyer is willing to take in the first place?
Okay, we should break some of these things down. But at the outset, I was mentioning, is there ever an occasion where you wouldn't need a lawyer in a personal injury case? Might someone who had a minor injury take on their own personal injury case, such as it is?
I mean, the insurance companies would like you to do that. So if there's an accident where you were hurt, you sought some treatment, and you've recovered, they want you to try to settle that without an attorney because they want you to settle for less money than you might otherwise get. That's your option. You can always do that, but oftentimes you probably are getting much less money than you would get if you enlisted an attorney who does that type of case.
You know, as I was preparing for this, I was thinking, how would a lay person have any idea about what the scope could possibly be? I mean, certainly they'd know if they went to the doctor, had an x-ray, some back problem, they did therapy. I mean, there's certain things that are very easily documented, and then, as you know, and we'll talk about shortly, it seems like this could certainly be something that they could have no understanding about, and how long it could go, and whatever. So whether someone is looking to do it themselves or knows that there's an issue here and an accident happens, I know we always start with what should you do, and having proof, documentation matters. So let's go through for our viewers, what should you do when there's an injury, when there's an accident?
So it depends, of course, on the type of accident. A slip and fall in a grocery store, for example, it's somewhat different than an auto accident, because in an auto accident situation, the first thing that you should do is make sure that everybody's okay. Check on the other person if you can, if it's safe, and then call the police. You want the police to come out, number one, to document the accident, and to the extent that it's a good report and they get all the facts correct, to have some factual basis as to what happened in the accident. Police reports aren't always correct, and there's oftentimes some things that are written down by the police officers that are factually wrong. Sometimes those can be corrected. But in the first instance, to have them there to document the fact that there was an accident is a very important first step in an auto accident case.
And assuming that someone is able to, physically able to, and not injured, we often talk about people have cell phones almost always. Are those photos that someone is able to capture right away before someone moves the car to get it out of that second lane or first lane or whatever? Does that make a difference in a case at times? Because once that car is moved, how does anyone really get to know some of those details?
Very useful, because stories will change.
Yes.
The report to the police officer may change if the cars are moved before the police officer gets there, and how will the police officer know who's telling the correct story in that circumstance? And oftentimes in that circumstance, the police officer will put down both versions if there are different versions. But it reminds me of some examples that I could give you. So someone's coming out of a parking lot and turning left onto a street. So there's an accident. And what happened in this particular case is the car that was coming down the street to the left stopped so that that other person could come out and turn left onto the other street.
Yes.
No one coming from the right, so the person proceeded to go out. And the car that hit the client turning, actually went over the double yellow line because he was passing the stop car. And that's how the accident happened. So the stop car leaves, the police come, and if the cars hadn't been moved and they're where they are and you took a photo of that, the story that the person who hit my client would have told was, well, he pulled out in front of me and turned left. But the photos showed that, no, you turn, and the client's story, well, no, someone stopped for me, that's why I went, makes more sense
Yes.
than I just pulled out and turned left in front of you. So the photo of where those cars were and showing that the other car was over the double yellow line was crucial, because usually under the law you can't pull from a safe position of safety to turn without making sure that it's clear to turn. So the person turning left, pulling out of the parking lot, would have thought to have been at fault, except for the fact that that's not what happened.
Interesting. So we know that you might need to, you have to call a police officer, call for an ambulance for medical attention if that's what's needed. But also, you might be able to take pictures of witnesses. What are the chances that an eyewitness to that accident is going to hang around until the police officer comes? How should you handle that when you, on site at that moment, know that there's someone who's close enough by who did see it? What should you do?
So in that particular instance, the person who stopped, they moved after the accident, but they stayed. Not for the police officer, but enough time for them to tell my client, hey, do you know what happened here? Because the client they hit their head. They were somewhat injured. Yeah, I'm not, well, I stopped to let you out and this person went around you. And so here's my name and number, and you can feel free to give that to the police officer, but I have to leave. So if you can gather as many names and numbers of people who were there and what they witnessed and what they saw, that's very helpful as well.
So I know you always talk about it's important to document and to gather evidence as you can. Understandably, when someone's in an accident, even if they watch this show and understand what you should do, sometimes when you're in that moment, you're confused, you're frustrated, you're upset, and less likely to do all of the right things that you might in a very rational state of being. So does it make sense that you should look around to see who else is there? And even if could you just take a picture of them? Can you ask just for their name? I know you're leaving, but if they do nothing more than that, would that be helpful? Because then it's not he said, she said, but it's also who happened to be a passerby or an eyewitness.
Yeah, so certainly the gathering of the names and contact information is really important. And it also should go to another type of accident in the same kind of situation where it's probably even more important, because you don't have a police officer coming, is you fell in a store or a supermarket or something.
Yes.
What did you fall in? It's important to show that if it's something you fell on that the store should have had notice was there and didn't clean it, so they were negligent in not maintaining the safety. If you can take a picture of what you fell in, or if it's a smushed banana that had turned brown and had been on the ground for a while, so much the better. And names of witnesses, really important, and notification to the manager of the store or some employee of the store as to what happened, and make sure that they take your name and number and report so it's documented that you were there. If it happened after you went through the register line, the cashier line, and you have a receipt, to save the receipt to prove you were there. If there are videos, to ask the store to save the video so that your lawyer can get it later down the road. All those types of things really help to document what happened
At that moment. So if someone ends up with a personal injury case, and say you're the lawyer, likely you'd need to go back to the store and see what other information you can garner, but the scene has been cleaned up.
Right.
Obviously, they're not going to leave that for the next 2 days or whatever it takes you or someone else to get there. So what other kinds of information would you glean from that situation if the cleanup on aisle 4 has taken place?
Right. So one of the things you would do is many stores these days have cameras in all the different aisles and all over the store. So as an attorney, we would write to them and immediately ask for the video. They might not give it to us right away, but we'll ask them to save it, because if they have video and they don't save it, there's a rule called spoliation, which means they let evidence disappear or is no longer available, and there can be an inference drawn from that there was something there that would have been helpful to the plaintiff's case. So that's a letter that, in a slip and fall case, you would send out to the store or the owner of the property or wherever it happened to say, if there is video, save it. And of course, you'd like to get the video because what would it show? You know, if there's some video that shows somebody came through the aisle and then 10 or 15 or 20 minutes later, your client went through the aisle and whatever they dropped on the floor you fell on, and there was enough time for the store to have cleaned it, it's very helpful to your case. Same thing with slip and fall cases outside, and you know, we talked about snow and ice recently. We haven't had a whole lot, but if there are some, and there's some video that shows that it snowed at 1 o'clock in the morning and that at 12 o'clock the next day the person slipped and fell and there had been no treatment done to the property, and it's a retail place, so to speak, so that you're expecting people to be there, then perhaps that's helpful to your case as well.
One other question before we move on to the idea of negligence that you were just bringing up and cleaning up and whatever. After the incident, whether someone is going it alone or working with a lawyer, how important is it, what kind of information should they save if they're not, say, journal writers, but how they felt if there was ongoing pain or other things that happen to their life that may affect things that they wouldn't necessarily understand right at the time, how their life was changed in minor or major ways that you may have to deal with if there were punitive damages or whatever else is going to come up, or suffering and pain, and how important is it, and what should someone document following the accident?
So in a negligent case, there is not punitive damages, but there is damages for compensatory things, such as pain and suffering, as you mentioned it. And it is helpful if someone keeps a journal or a calendar to show how they were each day and what they could do and what they couldn't do, and how the accident affected them from their day-to-day life and the activities of daily living. So that's a helpful thing. And the components of damages in a personal injury case are very much broken down into two things. One thing that's usually called out-of-pocket expenses, which would be medical bills, any kinds of things that you had to pay for as a result of the accident, lost wages, money that you couldn't earn because you couldn't work as a result of the accident, and then those things that go towards what you're talking about, pain and suffering, or your loss of enjoyment of life, things you can't do or couldn't do. If there's any permanency from a scar as a result of the accident, or loss of use of your limbs or ability to use your body as you normally would do it, those are also compensatory. So the day-to-day loss of use is something that's hard to remember as you get better and go along. So if you can document that, it's helpful.
I know there is such a thing as statute of limitations, and I guess the trigger's pulled the moment the accident happens, but honestly, people aren't taking someone to court the next day, and you're not involved in taking someone to court the next day. What is the statute of limitations? What is reasonable to expect in how a court case will play out, or a settlement, en route to a settlement? How does that play out, David?
Every state is different. So statute of limitations for a personal injury case is dependent on the state in which the injury happened for the most part. And in Rhode Island and Massachusetts, for a negligence case or a personal injury case, generally speaking, it's a 3-year statute of limitation, which means that you must file a lawsuit within 3 years from the date of the injury, because that's when you know that the right to that action has accrued. It's when the injury happened. Other types of cases, there might be a little difference in when the injury accrued or when you knew there was negligence, but for the most part, personal injury, auto accident, slip and fall, you know when you fell that somebody was negligent, or when you got hit in an automobile accident that someone was negligent, so that 3 years starts to run from that date.
Okay, and as you've touched on in several different occasions, negligence, there are some things that are very clear. If the pickle jar broke and they left it for 4 hours and someone slips, maybe that's fairly easy to know. But how do you go about determining negligence when it's not so readily apparent?
Yeah, so that's where a good lawyer can be helpful. So we talked about slip and falls in supermarkets, for example. And there's some difficulty with that because sometimes you don't know when the thing that fell on the floor got on the floor, how much time they had. So I remember, this goes back to the 80s, I had a case against a supermarket, and this was the slip and fall on the dreaded grape on the floor.
Grape, a grape.
And there were grapes on the floor a lot in the 80s. And this is why. And this was why my case, I looked at it and I went at it a little differently. Generally speaking, with a slip and fall in a market, there's usually something on the floor, and you have to prove that the store knew or should have known that that item was on the floor and they didn't clean it up. But I looked at this a little differently. And at that time, I don't know if you remember this, you might not be old enough, but they displayed grapes in these open bins, and you would pick up the bunch of grapes and you would put them in a bag, and then you would take the bag to the register and pay for it. But they weren't already in bags. And I think there were reasons they displayed them that way, one of which was they wanted you to try to maybe take one and taste it. Oh yeah, I like these, I'm going to buy more and buy them. So my argument was that the store was negligent in the way they displayed the grapes, because they knew people would pick them up, they knew they would fall on the ground, they knew they would be a danger to people who were there. So it was negligent display and negligent marketing of the grapes that I sued them for, rather than the standard slip and fall. And there were no cases in Rhode Island at the time on that, and there were very few but some in other jurisdictions. And we ended up settling the case, so it didn't make new law in Rhode Island, but that was my idea, was to make the law in Rhode Island to say that if you display the grapes like this so that you can sell more, then you're negligent whether you knew that particular grape was on the ground or not, because you know grapes are going to fall on the ground when people pick them up and put them in their bags. And so they have to sometimes think outside the box to find what really is the root cause of the negligence that you're suing for.
I guess if someone were thinking of handling a personal injury case themselves, they would have no frame of reference to take that approach, I would expect.
That's what I would say, yeah.
How about what's considered breach of duty? So you were referring to if it snowed at 1 in the morning and it's noon and you haven't treated your parking lot or whatever. That seems kind of reasonable, but if it snowed at 5 in the afternoon and at 5:30 someone falls, how do you get to determine, is that negligence? Is it what's feasible? And how do you look at that?
So that's the whole thing with negligence. First, is there a duty? So what would the duty be with the snow? What was the duty with the grape case? The duty is to keep the floor clean and safe from defects. Now, did you breach the duty? And the issue to that is, what would a reasonable person do under the circumstances? So a reasonable person who has snow on their property may not necessarily clean it up as the snow is falling down, because it's just going to get there. It could even make it worse. But once the storm has stopped and they had enough time to get out there and treat it and shovel it and sand it or salt it, and they didn't do that, then perhaps they breached their duty to keep the premises safe from defects. Whereas that grape case, the problem would have been, did they have enough time to pick up the grape? Do they have to stand there and pick up every single grape as they fall? Probably not. But that's why my focus wasn't on that the grape was on the floor, but how the grapes got on the floor. And they breached it by not making it safe for people to have a clean floor by displaying grapes in such a way that they knew they were going to end up on the floor, and that there was a safer, more reasonable way, prudent way to display the grapes by putting them in bags and letting you just pick up the bags so they're not falling on the floor.
Okay, let's talk about other causes, or maybe it ties into negligence. Break this down for us. Using your example, I was the shopper that day and I was wearing high heels. No, you didn't fall because of the grape, you fell because, you had some contributory role in there. I don't know that that is a contributory role, but when there are personal injury cases, likely someone is going to say, well, it wasn't just my fault, it was her fault, his fault. How does that play out?
Right. So to use either the slip and fall in the market or the slip and fall on the snow and ice.
I was wearing high heels that day.
I was either wearing high heels that day, or I knew it was slippery and I saw the snow and I still went there anyway and I fell. Is there some comparative negligence in Rhode Island, contributory negligence in Massachusetts, a little slightly different standard, where we can look at what the person who was supposed to maintain the property did as a contribution towards why this accident happened versus what the person who was walking did as a contribution towards the accident. And oftentimes, in a slip and fall case, there can be contributory negligence and both parties can be somewhat at fault, but you have to look at the circumstances of each case. Did the person who walked in the path have an alternative way to go where they didn't have to walk on the snowy path, or was that the only way they could go, and did they have to go at that particular time and moment and do that? So there may be some contributory negligence based on the facts. Another example of that would be the four-way stop sign. And you're driving and you have a stop sign, but you stop and then you go, but the person who also had a stop sign didn't stop and comes in the intersection and hit you. Well, if you have witnesses, that might be helpful to determining that you're not both at fault, but maybe one or the other's at fault. Or it may be a he said, she said situation, and there's negligence on both parties.
And so when you are either letting a judge determine how this is going to play out, or, as happens in many cases, there's a settlement, do you look at these contributory other factors in planning what point you'll pull the trigger and settle or be willing to? How does that play out for you?
Sure. So usually if it's a personal injury case, it's a jury that's going to end up determining that.
That's right.
But in settling a case, in valuing a case, in arbitrating or mediating a case, those are factors that the lawyer, both lawyers on both sides, will be looking at and determining what the full value of the case is. Here's the value of the case. You do have some responsibility for what happened, so you're contributory negligence, so we're going to reduce that by a percentage. And yes, you have to figure all that out as you're determining both what the value of the case is, what the settlement value of the case is, and how you think you should proceed with the case.
In the short amount of time that we have left, how long after you've filed a case, how long will it take before you actually get to sit down and discuss whether or not this is a settlement or settleable issue?
Right. So first thing you do is you always wait for the client to finish treating. If there can be an end point before you file a suit or try to settle the case. Once that's done, you pretty quickly can figure out what the value is and how to settle it.
Good to know. We hope that this has been helpful to you, and we hope that you don't have personal injury cases, but if you do, we hope that this has been helpful. Stay tuned to The Law Matters. We'll continue addressing these topics. It matters to you. Thank you for tuning in.